Well, Janine, thank you. Before I go into introducing the speakers very quickly, I just want to thank Janine and her team. I mean, this is a tremendous event, and the fact that you're able to get this kind of an audience on these key issues here year after year speaks to Janine's and her team's talent and dedication to this issue. So she's already behind the stage, but thank you, Janine, wherever you are. Just very quickly, and I know we're up against a hard stop. As Janine said, my name is Mike Burke. I'm a partner with the firm of Arnall, Gregory. I practice in the Washington, D.C. office. Don't hold that against me. I take no responsibility whatsoever for what's going on in and around Washington these days. But there I practice, I'm a corporate lawyer, so it's a lot of cross-border mergers and acquisitions and a healthy piece of regulatory work, specifically export controls as they impact this industry and shippers, and Foreign Corrupt Practices Act in general, anti-boycott compliance, or sorry, anti-corruption compliance as well as anti-boycott issues, but enough about that. What we're going to do with this panel is we're going to have each of the three speakers come up and give a brief statement. I guess in legalese we'd call that the opening statement. And then we're going to retreat back to the chairs and have more of a conversational approach. What we decided to do with this panel is to focus on three regulatory areas sort of within the bigger picture of upcoming and ongoing regulatory changes that impact this industry writ large. The first one, Jason Craig, who is the Director of Government Affairs at C.H. Robinson, he's going to talk about the electronic log, ELD, as it affects the hours of service in other areas in the trucking area. Second, Jaymie Forrest, who is the Chief Supply Chain Officer for Scantech, will talk about, and I missed that, Scantech Sciences, yeah, is going to speak about the Food Safety Modernization Act and certain areas that will impact especially Georgia's agricultural producers. And then last, Rhett Wilson, who is the President and CEO of DJ Powers, will speak about the automated commercial environment and some related issues affecting customs and where your paperwork goes. But I think in general, what we're going to do with these three pieces that may look to be very much apart is to weave them together to show that there is a bottom line cost and time investment that's imposed on this industry, on these changes, and that among other things, our Congress, our regulatory system in Washington may not be able to agree on much, but they can agree on how to regulate this industry, perhaps to the nth degree. With that, I will turn this over to Jason.
Thanks a lot, Mike. So as Mike mentioned, you guys are lucky enough, you get the economists first, now you get the lobbyists. So I do government affairs for C.H. Robinson. I've been at C.H. Robinson for 20 years. So before I did regulatory affairs, I actually was in your shoes in operations, moving freight. So when I read rules and regulations and propose laws, it's with a little different take, a little different spin than the rest of my colleagues in D.C. First off, I'd just like to thank Georgia Logistics Summit. C.H. Robinson's been a sponsor from the very beginning. I think this is what, our 7th year. Daryl and I were comparing notes. We've got a booth right out there, so if you have any questions, we've got about 10 people here in attendance. We'll be happy to answer those. First, I'd just like to set the stage for us in terms of where regulatory issues come into play in the transportation economy. As much as Mike and I like to think that the world revolves around Washington, D.C. and the federal agencies in Capitol Hill, we know that in the economy, transportation economy especially, there are a tremendous number of factors. And this slide kind of represents that. You see that regulation is simply one of them. It is one of the most visible aspects because it is predictable and you do see it coming down the line and it does get a lot of headlines. However, we shouldn't forget that things like overall economic demand, driver availability do play into account equally, if not more, out in the economy. So what we say up here, absolutely, does it have an effect? It should also be balanced by the economy as a whole and everything else that's presented today and tomorrow at this summit. So with that, one of the analogies that I draw all the time with regulation is a couple of years ago in 2014, you guys had Snowmageddon, right? And it seemed like our transportation system essentially broke within the span of 3 months. And I was doing a home project at the time, replacing some light switches, some electrical sockets, and I was putting the cover plate on. And it was one of those plastic cover plates, and I wasn't paying attention, and I turned the screw, and suddenly it cracked. How many people have had that happen, right? So I had to go back out to the store, but I realized that is a lot like our transportation system, our transportation network. There are all these factors that push and pull on it, but we don't quite know which one is the final screw that either breaks it or loosens it. I mean, how many people would have thought that driver turnover at small fleets would have actually increased tremendously? I mean, gotten better. They're retaining more and more drivers in 2015. That was a complete surprise that actually loosened capacity this year, one of many. So let's go to the next slide. I'm gonna cover electronic logging devices. This is a hot topic right now. Most people know that in December of 2015, the final rule was issued to lay out the mandating of electronic logging devices for all commercial truck drivers. There are a handful of exceptions. Folks who only use hours of service or record of duty statuses for 8 days or fewer in a month, 100-mile radius, local delivery drivers. There's also an exception for pre-2000 trucks because they don't quite have the technology necessary. But for the most part, in December of 2017, all commercial truck drivers will be required to be under electronic logging devices. A couple things to remember. One, this is still controversial amongst the carrier community, and OOIDA has filed a lawsuit on this, and they do have a history of winning on this. So while the implementation date is December 2017, there are a number of actions that could change that, that you have to monitor as we go forward. For those of you who do remember and who do follow this issue closely, OOIDA won on a mandated hours of service, a required ELD for chronic offenders on the issue of driver harassment. And I'll show you later on how that plays into the coercion rule. So some of the big issues that people have questions about. One is the cost. What's it cost? Between the draft rule and the final rule, FMCSA made some very some concessions to the small carriers especially, and they made smartphones compliant. They outlined a regime for smartphone compliance, and actually about 2 weeks ago I looked, and under the self-reported compliant providers on FMCSA's website, there was one that I called that had a fully compliant system that was $175 for a cable that hooks up to your smartphone, and either $30 a month for a 4-year contract or $50 a month for a 1-year contract. So in terms of cost, FMCSA estimated $584 in their rulemaking. We think that that cost is going to come down considerably since they did make the concession that smartphones will be compliant. Now, that is a minimally compliant ELD. There are also fleet management systems that do way more than just track hours of service, and that's where you see that rule of thumb, about 30% of all drivers are under ELDs currently because they do have some benefits to them. The next question that everybody always asks is capacity. How much capacity will this quote-unquote squeeze out? There are two different ways to look at it. The first is with a paper log, you log your hours in terms of 15-minute increments, and obviously with an ELD it's to the minute. So there's a certain amount of flexibility in that is lost. So whether that's 15 minutes a day, 20 minutes a day, who knows, that is an unknown. The second is that broader fear of many, many carriers out there operating under or not paying attention or having two sets of logbooks. The reality is it's easy to project fears into a broad, unknown carrier base, but we see time and time again that carriers are relatively resilient to changes in the marketplace and the rules and regulations. For example, the medical registry for doctors was changed in, I think, May of 2014. They really tightened up those regulations. We didn't really see much of an impact for that. But that unknown leads to a lot of fear. Not knowing how much capacity this could or may not squeeze out leads to fear. And I always reiterate that whether rates go up because of fear in the marketplace or rates go up because actual capacity is decreased in the marketplace, for those of us buying transportation services, the result is the same. Rates are still going up. So that emphasizes having a flexible transportation solution, a broad carrier base where you can access a lot of different capacity. Let's go to the next slide. So in conjunction with the electronic logging device rule is the coercion rule. This was actually implemented in January of 2016, and while it doesn't change coercion being illegal, and an example of coercion is if a driver says, I can't make that delivery, I'm gonna run out of hours, and you as a shipper say, well, could you do it for $200 more? That would be clearly coercion, right? That it was illegal previously, and there were risks and ramifications for that. What this coercion rule does, despite the name, is that it establishes a formal complaint process so that drivers can file complaints against shippers, brokers, and their own motor carrier companies, their company drivers. FMCSA then outlines a formal investigation process, but two things to keep in mind is that, one, it is very specific to the driver. You can put as much pressure on your 3PL as long as it's not the driver. You can put as much pressure on your dispatcher as long as it's not the driver. It is very specific to the driver being coerced. And the other is that there's a responsibility from the driver to state that they can't, that what you're asking them to do would be coercion or illegal activity. For example, you say, hey, I've got a 95,000 pound load, it's not permitted, can you take this? They would say, no, this is overweight. At that point, you cannot say, I'll give you an extra $500. The driver has to say that this activity would be illegal. FMCSA doesn't anticipate a tremendous number of these a year, but what is important is that the coercion rule works in conjunction with the ELD rule, because remember I said OOIDA has won once on this issue of mandated ELDs for chronic offenders. In that lawsuit, it was the issue of driver harassment that led to that rule being vacated. So the example I always give is a driver's 5 hours into an 11-hour run, and they had a lousy night's sleep the night before, and they deem themselves a hazard to the highway. They're sick already. They say, holy cow, I got to shut down. If an ELD is mandated and that dispatcher sees that, they can't say, I don't care if you're sick, you got to go. That's the issue that OOIDA challenged that rule on and won on. So you can see where that coercion rule is there to protect the drivers for exactly that. And once the coercion rule was in place, then the ELD rule could be implemented as well. So they work hand in hand. So with that, I'm going to turn it over to Rhett, and we're going to do some global forwarding, some international.
Good morning, everyone. I would first of all like to thank the Georgia Logistics Summit for having me here. Janine has done a wonderful job, and I'm certainly quite honored to be here. Again, my name is Rhett Willis. I am president and CEO of DJ Powers. We're a custom broker freight forwarder headquartered in Savannah, Georgia. We obviously are the focal point of a lot of regulation. Many shippers, importers tend to use their brokers and forwarders as the interpreter of regulations. So we see a lot of these regulations from both sides, the government agency's intent and the shipper and importer's obligation to meet those intents. I was asked today to speak about ACE, Automated Commercial Environment. Anyone out there who has read the JOC, Journal of Commerce, in the last 5 years has probably seen ACE all over that magazine. Anyone who has imported or is a current importer certainly has heard about ACE. There may be a few exporters out there who have not heard of ACE, but believe me, it's going to affect all aspects of international trade. The ACE is not new regulation. It is Customs' attempt to upgrade the current import regulations. They started this process about 5 or 6 years ago. They projected a $1 billion budget. Now, 5 years later, we're just now implementing, and the bill is run between $5 and $6 billion. Basically, what ACE does is it provides a single portal for the collection of data for customs purposes. The additional part of that is to allow all participating government agencies who are involved in the import process to also use that portal. So it is a single portal for the collection of data. It is also Customs' attempt to go paperless. Obviously, this is a big project. It was underestimated and under budgeted, but the government has persisted, and the first deadline for ACE implementation was March 31st. Importers themselves aren't or may not be affected directly by ACE. The burden really has fallen on the IT providers who have the operating systems and the custom brokers. We're the ones who've had to go out, adjust our systems, make sure we can report to customs in the data formats requested, with the data requested, on the timelines requested. It has been a major undertaking. It has given us 5 years of headaches, a lot of gray hair, and fortunately, my import managers have not abandoned me in the process. Nevertheless, we are there and we are filing. There is also an effect on exporters under the ACE program in that the shipper's export declaration, or the electronic export information, is currently being filed under ACE. Whether you know it or not, your freight forwarder should be filing that export information under ACE. The implementation dates, the first one, as I mentioned, was March 31st. There's going to be a secondary implementation date on May 28th. The remaining PGAs, or participating government agencies, incorporation in this, will occur throughout the summer of 2016. These are dates that have been moved back several times, but as often is required, when you have something this large and this all-encompassing, there are going to have to be adjustments made. So fortunately, Customs did push it back, but it's been a tough road to get to this point. Again, what does it provide? What are the benefits? ACE provides a single portal for all data. That includes Customs, Food and Drug, USDA, DOT, and eventually all the government agencies that are involved in the import process. It creates a paperless environment. We are now moving quickly to a paperless submission of entry, paperless submission of ITs. Food and Drug are going paperless. Lacey Act under USDA is going paperless. So for those of you who are involved in the trucking, you understand the paperless IT. A lot of truck drivers get real nervous when they don't have an IT to sign off on. Lacey Act, I think Customs pushed this on to USDA with USDA not being exactly ready. So there were some issues there, but nevertheless, we march ahead. Another benefit of the ACE program is called cargo release. And what this does is it allows the broker to file the entry immediately after departure from the port of origin. Previously, you could only file 5 days prior to arrival. Now, you can file as soon as you have the paperwork, immediately after the sailing at the origin point. This is going to give much more timely release of cargo. It allows for edits and corrections if there's an error in the original submission. and generally will smooth the process quite a bit. The other thing that this early release allows, as I mentioned, is for a better edit and correction of paperwork. And this will come into play later, but often there's simple mistakes made. The commercial invoice doesn't match the entry description. Many things that you as importers have probably experienced. We're now able to go in and do an edit and a correction online quickly without having to resubmit, withdraw the previous entry and resubmit. So it's going to streamline the import process quite a bit. One of the other benefits, not necessarily for my industry, but certainly for importers, is it will eliminate the need for outport brokerage. Previously, if you had quota, or you had FDA, or you had other government agencies involved with your import, and you're coming in to the West Coast, East Coast, the Pacific Northwest, Gulf Coast, you'd have to get an outport broker. With ACE, we're able to file all the documents for all the PGAs at a single portal from a single source. Importers of record. You often have to go to your broker to get your information, to see where you are, what's happening with your account from the customs-facing side. Under ACE, there's a portal for the importers. You as an importer can go on, you can look at your entry count, you can look at any notifications from customs, you can see the dates which your entry was filed and the dates which your entries were released. So it really gives you hands-on information and a check on the performance of your broker. One other aspect, and I guess we could consider this a benefit, but Customs has established centers of excellence and expertise called Cs, CEE. What they're doing with the Cs as a result of having this collection of data in one source is they are setting up centers throughout the U.S. where they're industry-specific experts to review the entries. This is good in one aspect. It will give you a more specific response to a specific inquiry you may have. The people processing and analyzing the entries generally will have industry-specific knowledge, so there's a faster response to your questions. And if there is an issue, because of the cargo release, we can now go in and do an instant editing if in fact they do find that there's an error in the entry. So what are the disadvantages? Well, guess what? Customs has greater access to the import data. That means Customs can see everything you're doing, FDA can see everything you're doing, USDA can see everything you're doing, and it's all together in one big data source. This creates, obviously, the potential for increased fines and penalties. Before, if you were filing in different ports, and we have had customers port hop many times, maybe there's a preferable port for a particular item, those days are gone. We have seen, in fact, an increase in penalties and fines coming out of Customs, and in part it is due to their ability to better assess your data. What happens? Inconsistent data, late data will get Customs' attention. You're going to have to be much more accurate in the information you submit. You need to be much more aware of requirements and be aware that the Customs will be able to see these inconsistencies. Compliance is going to be important. It's going to, for all the importers and for exporters as well, you really need to focus on compliance. One of the previously implemented regulations is called Importer Security Filing, ISFs, and that's data that's required to be filed prior to loading of the vessel. that data has to match your entry data. Probably 50% of our importers file it timely and file it accurately. We're constantly chasing them. The penalty for a late filed ISF is $5,000. The penalty for an incorrect ISF, $5,000. Maximum $10,000 per ISF. That ISF data is matched to the entry data. It has to be correct. Customs has entered a new phase of penalties for ISF. So if you're importing, be ready, because if you are not filing timely or you're not filing accurately, you can expect a call from Customs. So what are the net effects? Customs now has the ability to target cargo for inspections. One thing we run into with clients is they'll bring in large numbers of containers on single bills of lading, and they'll get an ag hold. Agriculture wants to inspect. This is going to increase. We notice a large increase in inspections. Be aware when you're setting up your supply chains that if you have large pulses of cargo and there are errors in your data, it can hold you up. If they want to inspect one container, the other 29 have to sit. And if you get into demurrage situations, you get no sympathy from the federal government. Again, exports, SED, watch your data, make sure it's filed timely. One thing we run into a lot is that customers come to us and expect the broker to handle all of this for them. And if there's any problems, they want to go to the customs broker and say, why didn't you do this? And you're responsible. The MOD Act was passed some time ago. I don't know the exact date. But basically, what it does is it establishes responsibilities for the importers of record. You are responsible regardless of the action taken by your broker. So, if you aren't sure if your data is accurate or correct or timely, you need to make sure that internally you have a due diligence and compliance program, and you need to make sure you discuss that with your broker. Again, there is a wave of regulation coming. There are other regulations that I'm sure y'all are aware of. ACE is here. It actually has an objective to go paperless and to combine the data collection through one portal. There's a defined benefit. There is a enforcement process because Customs has a badge and a gun, and also there's measurement. You can go onto the portal and look at your account and see exactly what's going on with Customs. I put on the slide here the websites, and I'm sure it'll be available afterwards. I suggest you go onto these websites, read it, look at what's going on with ACE. You as an importer should have a portal, and there's quite a bit of information there that I think you'll find beneficial. And we're certainly here for questions afterwards.
This music's playing. I'm not dancing for anybody. Good morning, I'm Jaymie Forrest, the Chief Supply Chain Officer at Scantech Sciences. I asked myself the question, why am I actually doing the legal section? But as Chief Supply Chain Officer, I have lived, eat, breathed, died lately following this act, the Food Safety Modernization Act. And if we can go ahead and pull up the slides. So as Chief Operating Officer, lately I've been very focused on our material handling system and what kind of contamination it can cause. What is our temperature control processes, engaging with carriers in and out of our facilities? What are their warehouse labor programs going to be? What is their responsibility with regards to safety and hygiene? And so Scantech Sciences, we build and operate food safety treatment facilities, both for domestic and international. And so we've been very focused on this law for some time now. There was a food chain research center that we started at Georgia Tech 6 years ago in anticipation of this law, very focused on best practices in cold chain management in order to be prepared. So hopefully I'm qualified to talk to you about this today. So what is the rationale for this Food Safety Modernization Act? Really, it is to modernize our food safety system in the US. There has not been any changes or laws introduced in this area since 1938. So how many of you heard of the Chipotle scare over the last 6 months or so? So it is important now that we're seeing executive officers being criminally prosecuted for food safety. So all of a sudden there's this big perfect storm of this act going into legislation and actually starting to be implemented now. And in combination with all of our, we mentioned earlier, all the millions of people that are growing, and how do we actually begin these programs for food safety and food treatment. So Scantech Sciences has developed a new pasteurization technology that basically we're a big third-party logistics company that will be building these facilities to start treating food and handling all the operations and cross-docking of getting those, that food in and out in a properly treated environment to help maintain the cold chain. So this law is very focused on prevention. The previous way we behaved was really more reaction. What do you do if there's a recall, or what happens if something goes wrong in the supply chain? But now we're actually being responsible and accountable for preventing these as our food is moved through their distribution process. So this law also mandates now that the FDA sets standards, and anytime those standards are being set, you know, we as the industry now have to follow new protocols and new processes. This is also, if you, as Rhett had mentioned, if you're the importer of record, you are also responsible for compliance in this food distribution process. And this also gives the authority for the FDA to administer mandatory recalls, and they can stop the ability of trade and commerce and shipment if they suspect there is something wrong with the food. We used to actually have to go through a process where you were kind of innocent until proven guilty, but that is no longer the process moving forward. So there's 5 key areas in the Food Safety Modernization Act. The first is around preventive controls. The second is inspection and compliance. The third is really focused on importing food safely and being sure that you as an importer of record, or you as a supply chain host, if you will, with all your foreign suppliers, that you are responsible in validating that they have the same preventive controls for that food to be entering into the US commerce. There's also a response section. Again, these are the new authorities that the FDA has. I mentioned the recall. Also, there's an expanded administrative detention of products that they can do, as well as suspending a facility's registration. And then the last one is really focused on enhanced partnerships. This is a big problem and a big concept, and it's not something that can be enforced just by the FDA alone. The state of Georgia, we have filed for an application to receive some implementation funds, if you will, from the FDA, and we'll be looking to kind of bring together US, federal, local, and foreign entities to all work together to actually ensure that this act is enforceable. So there's 7 laws that fall underneath the Food Safety Modernization Act. I went ahead and put the 7th one on here. The last one is still proposed and pending. But the first 6 here have actually been finalized, approved, they're registered, and now the clock is ticking for all of us to actually get our programs and our processes in place. The first and the second are preventive controls. The preventive controls rule actually includes hazardous analysis or hazard analysis, and there's a lot of detail in what that means now and what you have to do in order to be compliant. It's not good enough to just take your good manufacturing practices of the past, because they have been enhanced now. So you need to take your old programs, evaluate them, add to them, and really try to move forward quickly into this compliance realm. The third law is the produce safety law. Being an agricultural business here in Georgia, this is very important to a lot of our local production areas, and understanding what that produce safety rule. We will try to spend more time on the transportation and logistics, and they did ask me to talk a little bit deeper into this law since it was so complicated. The fourth one is the accredited third-party certification. So that is enabling the FDA to hire and certify third parties that will go in and do audits for the foreign facilities. The fourth one is the foreign supplier verification programs for importers of food. This is where you're now responsible for the supply chain of that food distribution prior to you actually taking control of that product. And then the last one is the sanitary transportation of human and animal food. That one is still under comment period, but it is, I can give you the schedule here in a second, but it's right around the corner. And the last one, protect against intentional adulteration rule. I don't want to spend much time on that because the law is not final, but the actual terminology for that law is in reference to contamination, so it will also affect everyone. So what types of companies are held under this new compliance? If you're producing farm, then obviously you fall under a certain category and under the produce safety rule. If you are a secondary farm, you should really look into the definition of that because it really eliminates a lot of the burden for you. But if you don't fall under that, then you definitely fall under preventive controls if you have anything to do to manufacture, pack, hold, label, transport, or an importer of record around food distribution. Everyone else is included in this act. So shippers, receivers, and carriers who transport food in the U.S. by motor or by rail, whether or not the food enters into commerce in the U.S., you're still under the obligations during the transport portion of that food distribution. If you are a person or an entity that is an exporter, where that product is coming into the United States not for commerce but just transferring through the United States, then you are exempt from the regulation. But those of you that are bringing containers in that then gets transported into either rail or some type of motor transport, then you're responsible for that while that product is in transit in the United States, if that food is going to be consumed or distributed in the US. So this is the compliance calendar. We couldn't make it easy. We had to have everything on a different schedule, and what I tried to do here is really just kind of organize it to get a glimpse of when you actually have to be under compliance. And all of them are based on the effective date. Most of them are 2 years or 1 year from the effective date, depending on what size of your company. So the larger ones are in the dark green. For instance, the preventive controls was passed in September. So September 2016, we are under compliance now for most of the companies that distribute and transport food products. You would be classified as a large company. The preventive controls, there's also a schedule there for animal food or animal feed, and those break it into whether you have to have your general manufacturing practices updated versus preventive controls, and so that's what the GMP versus PC is. And then the foreign supplier verification program there at the bottom is 6 months after the compliance date for your supplier. So if your supplier is a large, small, or very small, you're on a 6-month schedule from the size of that company. And then the adulteration or contamination law is question marks. It's not been finalized in the registry, but it will be sometime in the month of May. It will be registered. And the sanitary transportation rule is brand new. It went into the Federal Registry April 6th, so 2 weeks ago. So the clock is ticking now on this one. And there's some really big implications in this one. I think this is one of the ones that really is going to take kind of the most time to get your house in order to be compliant. So the larger companies, that would go in effect for you in June of 2017. And the smaller ones would be the following year in 2018. So what are the challenges? And there's so many with this. I just tried to kind of pick some of the highlights. Some of these are things that I'm knee deep in, so they're kind of fresh on my mind, and I know how difficult they are to do. I know how expensive it is and what it's costing us to support the compliance for this act. But the hazard analysis, again, I already mentioned, you need to go back and take a look at that. Your old protocols are not necessarily going to be compliant. You know, for instance, have you really assessed the probability that certain hazards are going to actually affect the food in the absence of control? So there's some really detailed things within these laws that really require a little bit of meat and some diligence, if you will, about your protocols and your procedures. The foreign supply verification program is not only difficult. I was working with the executive for Nestle, who is responsible for 150,000 suppliers in Latin America. You know, how do you comply? How do you enforce this? It's very difficult and it's very expensive. So there's going to be a lot of burden on really trying to either consolidate our suppliers or figure out a way that we can actually help them facilitate through this program. Establish food safety programs. We all have food safety programs in place if you have been in this space or in this business for a while. But now that food safety program really needs to be focused on things like traceability. Are my systems up to date? I have spent a good chunk of this year really focusing on the logistics information management systems. What is the capture? What is the data exchange? What is the traceability requirements? How am I going to feed back this information in a timely manner? How do I report within 24 hours if there's a problem between me and my supplier or me and one of my receivers? So those are the things that are going to make this a little bit more difficult, and it takes a lot of time and it requires collaboration. Temperature control, temperature monitoring and control. You need to have an integrated program with either the receiving end or with the shipper if I'm a carrier. So being in the middle of that conversation is something that really needs to start now, because I can tell you it takes a lot of work to get these programs to where they are kind of lock solid with the right data information and the right data exchange. The other thing that I would want to mention is think about your marketing, think about a recall, think about a press release. Who's going to announce what? If you don't announce, I just came from an importer workshop that the FDA gave last week where it was for importers to get prepared under this new law for recalls. And the big question in the room was, okay, if we don't say anything, then the FDA can now put out a press release for you. That is not what you want. So you and your collaboration with both your suppliers and your carriers needs to take place and think all the way through. It's not just the food safety director's job, it's the chief supply chain officer's job now, it's the head of marketing. It really takes a whole team approach to address the new implications of this law. Okay, getting started on the Sanitary Transportation Act, I mentioned that. It also references the Transport Acts of 2005. So you do have to go back and understand the implications of that as well when you're putting all of your planning and your protocols together. And this particular act, the Sanitary Transport Act, involves the vehicles, it involves all the transportation equipment and all the transportation operations. So it isn't just about having those procedures, it's also about the exchange of all the information around those processes and procedures. And then the last kind of meat of this law is really focused on documentation. So if you do a training program, a hygiene program for your warehouse labor, that's, you know, we're trying to work through what do all those training programs look like now. Those need to be documented. You need to not only document the training material, but you also need to document your process of training those individuals and really focusing on the personnel and the practices and what are the things that they could be doing within your facility that someone may come in and deem as causing cross-contamination or putting food at risk. So the training and the records have become really what I would call a burden in that there's a lot more layers of things that need to be captured and articulated. The last slide I have here is resources, and this outline was kind of put together by the planning group for the Logistics Summit, and they wanted to just really be sure that there was some reference material for where people can go to get more information and get help. There's a lot of really good information for a change. Our government has done a really good job of putting fact sheets, presentations, webinars, guidance for the industry on this particular act. You can also submit questions into a technical assistance network. They will answer you. We've been testing that. We've been sending some of the gray areas that we're trying to figure out. Sometimes they won't answer you. They're vague, but you'll get a response back anyway. There's an online course that's going to be developed that they are going to post onto the website as well. And I believe, from what I understood last week from the FDA, that training program that they're going to post is something that you could actually use as your own training program, and it would qualify to meet their regulatory requirement. There is a webinar coming up on Monday. You do not have to register ahead of time, but it's April 25th on Monday at 11 a.m. Eastern. FDA will be giving a webinar on the new sanitary transport rule. So this is kind of like first glimpse at all the final implications that ended up in the law. I have been reading a lot of Food Logistics magazine articles. I find them to be very helpful. A lot of times reading all of the regulatory gets kind of mind-numbing, and it's all starting to run together and confusing. They do a really good job of just kind of creating some very concise clips on what the impact is and how to interpret it. And then also most of the associations now are offering workshops. So the Grocer Manufacturers Association, United Fresh, the Produce Marketing Association, they all are starting their rollouts of educational workshops. And I've attended several of them, and they've been pretty good. Great. Questions? Good job.
Well, great. It does work. I'm looking at the clock, and it does say 0, but I think I'll exercise a bit of discretion and at least try to get to just a little teeny bit of discretion. I know that we have a hard stop for the lunch.
We're good. You
We're
guys
good?
can go in a little bit longer. I think there's a lot of material here. We've got some questions
Well,
coming in on the app if you...
That was
Here you
what
go.
I was looking at, and I think the number one question right now actually looks like it was intended for Rhett, but I think it might be applicable all along for the three of you, and it relates to the False Claims Act. For the non-lawyers in the audience, I think that's a lot of us, a lot of you. I am a lawyer and I play one on TV, obviously. False Claims Act is a statute that penalizes making false statements, providing false records to the federal government in various contexts. In the customs world, I know this has been used as a sword by customs against importers. And, the question is, how do we think ACE, and I think I know the answer to this, but, ACE increasing the possibility of False Claims Act proceedings against importers of record, say?
Yes, regarding ACE, I think what we have found is that when customs places a penalty, the first thing you need to be able to do is to show due diligence in your attempts to provide the correct data. What is due diligence? If you ask customs, they won't give you a de minimis, but I think that accurate record keeping is important. You need to make sure that it's communicated correctly to the broker. And when a broker files an entry or submits documents to any of the participating government agencies, it is still the importer's responsibility to review the entry, to review it for accuracy. There are customs messages that come out every day, probably 300 or 400 a year, regarding anti-dumping, countervailing duties, and these are things that are often misinterpreted. Could they be considered false information? Maybe you entered into it innocently enough, but we're not up to speed on the new regulations. So again, compliance is critical. Communication with your broker is critical. Validation of the information that you're giving them is critical. And you need to check behind them to make sure that the information being submitted is correct and accurate. All of the importers have access to the portal, and you can go online and you can see your entries. You can see any customs messages, a CF-28 or CF-29, where they're requesting data. One thing to keep in mind, and we've had this happen in the past, people will get a notice from customs requesting data, and it gets passed around from desk to desk to desk, and no one knows what to do with it, or maybe they hope it'll go away. It's a wrong thing to do. And I think the best defense against these penalties is a quick response to customs, and again, a show of due diligence in the attempt to do the right thing, because there's so many regulations out there. It's quite easy to step in a pothole accidentally. And customs will consider that. But again, the level of compliance required with the new wave of regulations is certainly higher than it has been. And importers and exporters need to put renewed attention to their internal compliance.
Well, and Jaymie, I'd ask a similar question, sort of I know the Modernization Act is incredibly broad, and we could probably spend the next few days talking about that.
Yeah, and unfortunately, by the time you figure it all out, you've lost the load because it's perishable.
Right.
So, you know, truckload of strawberries is worth almost $50,000 right now, and chickens, you know, double that. So it's too late. Yeah.
Well, and Jason, that gets to the point about the hours, you know, that we had talked about. I mean, you know, it seems to me, you know, if you're going to have these logs accessible by the Federal Motor Carrier Oversight Commission, and I know that's not the exact phrase, but
Don't worry.
I'm getting close enough, but you know, it strikes me that you've got a potential there not just for the carriers, but maybe for the individual truckers, to the extent that these records, if they're adulterated, go up the chain.
Well, the reality is we could talk about a number of other issues, hours of service and where that is in the process. We could also talk about CSA reform and the safety fitness determination rulemaking that we didn't touch on. There's the issue of the California wage, meal, and rest breaks, the F4A issue out in California. But if I could leave everybody with one kind of insider tip that I think might surprise a lot of people in transportation and logistics, how many people are here are in the HR department in your company? Anybody? Oh, we got one. So there's a potentially big rule coming out that would change the overtime status for employees from $23,000 to $50,000. If you are in charge of warehouse staff, I would go to your HR folks and ask if that is potentially going to, how that works and how that would impact your warehouse operations, because that could potentially be an issue mid-year, July through September, because it could be an election year issue as well. So that would be the one kind of insider tip I'd leave everybody with.
That might be the one election year issue, because everything else is so
Everything
calm.
else is set.
One of the questions that's come up, and I know that we did not have a speaker talk about the Solus, the container weight issue, and I'm looking at this is a great app if you guys have not downloaded it yet. So the question's been repeated by 11 people. I don't know if we can give a 30,000-foot overview on Solus and those issues, or if there's a resource we can point to. I know that we sought somebody for this panel, but weren't able to.
Sure, I can handle it. I think the rule of thumb on this is that you're going to have to be comfortable with ambiguity. That nobody knows exactly how July 1st is going to be enforced. You're going to have to be prepared. Obviously, the minimum requirements are to transmit your information through ACE, through your broker or your export partner. But the reality is, you're going to have to be flexible. People, from what I've seen, people want certainty on, well, is a 5% tolerance going to be acceptable? Is a 10% tolerance in weight going to be acceptable? Unfortunately, because the Coast Guard is in charge of enforcement, we may or may not get certainty on that. So that's not an answer everybody likes, but that's going to be reality. Is July 1st. You can prepare as much as you want, and then we'll see what happens July 1st.
Sure. Yeah, we do have I don't know if they can pull up PowerPoint, but I put a slide together with reference, if you can pull that up. One comment about Solus, and that is that Solus was implemented, which is safety of lives at sea, implemented by the International Maritime Organization. They really have no jurisdictional law jurisdiction in the U.S., so they can't make it law here. There's some things they've done. One is to require the shipper to be responsible for the verified gross mass, which includes the weight of the container. That in and of itself requires a double weighing of the container. And many shippers understand the weight of their cargo. The issue again is adding the weight of the container, which they can't control, and then the shipper having to report that. So if in effect you weigh the container as it goes into the port, that has to go back to the shipper. The shipper has to then turn around and submit it back to the carrier. There are a lot of issues with the SOLAS rule that aren't addressed. The rule itself is only, what, 3 or 4 or 5 lines?
Well, and an important point is that it's not U.S. law, it's international law.
Right, and we're signed on as a convention to the IMO, but the implementation is not there. The enforcement process is not there, and the measurement is not there. And really, to have a good regulation, you need an objective, you need an implementation schedule, you need a measurement for compliance, and then you need an enforcement. And most of those are missing in this case. So it'll be interesting to see come July 1st.
And I think for the last, shifting gears just a little bit, maybe for our last question, Jaymie, I'll throw it to you, which is the scope of the Modernization Act, whether it's dry grocery, cold chain. I think there's some in the audience. You mentioned the strawberries.
It's food distribution.
It's food. It's
Yeah.
it's
Any
anything
food,
consumable.
Anything consumable
No.
by a human or an animal.
Except the sanitary transportation rule is very
Right.
specific to that shelf-stable food is exempt from that.
Yeah, correct.
The sanitary transportation food rule is specific to fresh food that's open to the air, essentially. So a bag of potatoes, a clamshell of strawberries, something like that, and other temperature controlled required, like yogurts or stuff.
And there are a few exemptions if you fall under other programs, like the retail food program or the grade A milk sanitary program. But as he mentioned, under just that one rule, the Sanitary Act, there's some exemptions there. However, all the other acts still fall back under preventive controls, hazardous analysis, with how those things are packed or put together or handled prior to that point of transport.
That's great. And looking at those numbers that are now bright red.
Yeah, we're on the alert
But
there.
thank you, Jason, Jaymie, Rhett. This has been fantastic, and I hope the audience, you've all seen kind of what's coming. Although I think with ACE, we're already there. With food safety, we're phasing in. With trucking, it's going to be a Christmas
Ongoing.
gift that keeps on giving. But before we wrap up, again, Janine, I want to thank you and your team for putting this together. And I think the materials are on the app. If people download the app, you can access the materials and you can get some more information about us and ask us questions offline. Just very quickly, I want to add in on a point of, I guess, personal privilege. My firm, Arnall, Gregory, has been thrilled to be a sponsor of this event. I think from the almost, if not the very beginning, almost from the very beginning. And we're going to have a lot of members of our logistics team at our booth, and if people want to stop by, that would be great. I think we're right next to you guys, so we can compare notes. But thank you, Janine, and thank you, three, for today.
Thank you. Thank you.